Okay, so this piece is about a very old piece of legislation to do with house purchases. It's a piece of legislation that goes back to 1925. It's the Land Reform Act, I think it's called, 1925. So it's nearly 100 years old. Although modified, this is a United Kingdom law I'm talking about, and particularly England and Wales law I'm talking about. Although modified by various precedents since 1925, the Land Act still holds. And when you buy a house, there's a couple of ways to do it. But basically, since that act in 1925, you don't own the bricks and mortar anymore. In England and Wales, you don't own bricks and mortar. You have your name down as being a trustee. So it's like having a container, a legal container that holds the bricks and mortars, and via this linkage of being a trustee, that's how you own a property in England and Wales. And I think other countries largely follow this model in a lot of ways. Okay, there's some great things about property in the United Kingdom. You know, you're probably not going to find there's a water pipeline suddenly going to appear in your back garden and you're not compensated and stuff. But the way that you buy it is either by, let's say there's two people, because there often is, but let's say there's two people buying it with a joint mortgage. You either buy it by being a joint tenancy, that's one method of trustee buying it, or tenants in common. Now, a lot of people who are couples or who are two people that know each other well will buy as a joint tenancy. There's a slight problem with this though. Let's say that it's a slightly unequal partnership. It could be that the man earns a lot of money, the woman doesn't. It could be that it's an offspring of a person and one of their parents, surviving parent perhaps. And you know, there's different ways to look at it, but basically, let's say they buy it as a joint tenancy. So far so good. One of them dies, the other one gets the whole property. And that's the basis on which many people go into this whole property buying business. What a lot of people don't know, and this is a little bit like learning about divorce before you learn about marriage, is that the day after you've moved in, the party who decides to unilaterally split the joint tenancy agreement and turn it into something called tenants in common just has to issue a piece of paperwork on their own without you seeing it. The notice that comes from the land registry to tell you that this application was made on their own without you seeing it, that can be appropriated by them. If they're in the house more, for example. So you have a situation where you go into an agreement where maybe you're the main mortgage provider. Maybe you're the one that the building society actually accept as being the one that anchors the mortgage, but actually the other person seems to be getting into it half and half in a joint tenancy basis. But of course, if one of you dies, the other one gets it. All of it. No regards to a will, anything. The other person just owns it all the day that one of the parties dies. If they manage to get a joint tenancy dissolved by issuing a thing called a notice of severance, which severs the joint tenancy, turning you into tenants in common, it could be the day after you move in. And it's, as I say, a unilateral event, as Judge Henderson put it in a judgment on such a case. There's complicated precedents to why this is. But basically, without you knowing or finding out, you could find yourself in a situation where you believe that when the other person dies, you not just inherit, you actually take ownership of everything. But in fact, when they die, because the notice of severance was issued and the joint tenancy was split and turned into tenants in common, when they actually die a few years down the road, half of the property goes according to their will. So unless their will says that it goes, their half goes to you. It goes to a whole group of other people, possibly. I'm not talking about a particular case in particular, but it's quite possible that other relatives could then be party to a property that you thought, when someone died, you inherited the whole thing. And I'd like to say it's not even proper inheritance. You actually get to own it. It doesn't have to go through a will with joint tenancy. So here's what I say about this. The notice of severance, in effect, is a scam. It's a scam that's been allowed for a very long time. It's time it was stopped. You should need a court order. Like with a divorce, you should need a court order in order to have a notice of severance issued. Now some people say, but what if you want to dissolve joint tenancy? Well, if you both feel that way, you can just go to a lawyer and fill in a form and send it to land registry. No need for a notice of severance in that case. That's not a case that happens very often. Okay? Joint tenancy dissolved and turned into tenants in common by a notice of severance. It's an absolute scam and it should be stopped. Thanks for watching and listening.